Hello. Today we are going to study the topic vicarious liability in tort. We will understand what is vicarious liability, in what circumstances are vicarious liabilities imposed. Now, what do you understand by vicarious liability is the first question. Generally, a person is liable for his own wrongful act, and one does not incur any liability for acts done by others. So, for example, I will be liable for the wrongs which are done by me. My wrongful acts are my responsibility and not somebody else's wrongful acts. But there are certain circumstances and certain cases where vicarious liability is imposed. Now, what is that? It is a liability of one person for the acts done by others. So, I may be liable for acts done by certain other persons who I might have control on authority on. We will understand the circumstances. But vicarious liability essentially means liability on me for the acts of somebody else, the wrongful acts done by somebody else. Now, in order to hold A liable for the acts of B, in order to hold A liable for the acts done by B, it is necessary that there should be certain relationship between A and B. And the wrongful act should be in a certain way connected with the relationship. Now, first, there should be certain relationship between A and B. Obviously, to hold somebody liable for the act of somebody else, there has to be a relationship. I cannot be held liable for the acts of a passerby. Right? Now, that passerby, I do not even know. I cannot be held liable for them. Correct? I will only be held liable if there is certain relationship which I share with them. Second, even if I share a relationship with them, I cannot be held liable for every wrong that they have done. That wrongful act should be connected with the relationship that happens. This is very important. So first condition, there has to be certain kind of relationship. We will understand what kinds of relationship do vicarious liabilities fall under. And second, that the wrong which has happened should happen because of that relationship. It should be connected with the relationship, not be an isolated act. So, vicarious liability generally arises in the following situations. There are three situations majorly. First is liability of the principal for the torts of his agent. So, agent-principal relationship. The partners for each other's tort, so partnership, and the liability for the tort of his servant. So the master's liability for the tort of his servant. So the relationships we will talk about are three: principal agent, partners, and master servant relationship. Now understand these are the relationships, and the act for which vicarious liability can be incurred should be related to one of these relations. Okay? And the act should be in the course of fulfilling these relationships' duties. Now, first let's understand what is principal and agent. Where one person authorizes another to commit a tort, the liability for that will not only be of that person who has committed, but also who has authorized it. Now, what is a principal agent? If I employ somebody to do work for me, so that will be on an agent basis. That person will be an agent. So I authorize that person to do something. While doing that thing, if the person commits a tort related to the activity I allowed, then it will be a liability, vicarious liability on me also. It is based on the general principle qui facet per alium facet per se, which means the act of an agent is the act of the principal. So the act of the agent becomes the act of the principal itself. For an act authorized by the principal and done by the agent, both of them are liable. So it will be a joint and several liability. We've understood this concept in the last lecture. So the liability of a principal and agent is joint and several, and the principal is vicariously liable for the acts done by the agent in the course of his duties or in the course of employment. Now, when an agent commits a tort in the course of performance of his duty as an agent, the liability of the principal arises for such a wrongful act. So the principal has given authority to do certain acts. While in the course of performance of those duties, if the agent does any wrong, then only will the principal be liable for the wrongful act. Obviously, the agent is also liable because he has done the wrongful act. And the principal becomes vicariously liable because he has authorized the doing of an act. The principal is liable vicariously because of the principal-agent relationship between the two. Both can be made liable for the same wrongful act. So the same wrongful act, both will be considered to be liable. They are considered to be joint tortfeasors and the liability is joint and several. We've understood it in the last lecture also. Principal agent are joint tortfeasors. A wrong done by the agent will be the wrong done by the principal also. In such a case, the plaintiff has a choice to either sue the principal or the agent or both of them. What is important is that the relationship should be there of a principal and agent, and the wrong should be done in the course of performance of his duty as an agent. So you must be doing it in the course of performance of your duty, not otherwise. Now, the authority to do the act may be express or implied. So, for example, if I am a principal and I tell my agent to go and supply something somewhere, that while supplying something, he does a tort. It is in the course of performance of his duty. Now, second thing, express or implied. I may expressly tell him, go as fast as you can. So, I have expressly told him to drive rashly or negligently. Or I may not tell him, but there is an implied scenario that I have to do it very quickly. So I may, if the agent does it, it will be a wrongful act. The principal generally does not expressly ask his agent to do the wrongful act. But when the agent acts in the ordinary course of performance of his duty as an agent, the principal becomes liable for the same. So generally, you are not liable expressly telling the agent to do the wrongful act. But when you do it in the course of performance of your duty, the principal becomes liable. Now, this is a case, Lloyd versus Graysmith and Company. This is a landmark case which deals with liability of the principal and agent. So, Mrs. Lloyd owned 2 cottages, but was not satisfied with the income that came from those cottages, and she approached the office of Graysmith and Company, a firm of solicitors, to consult them about the matter of her property. So she had contacted a firm of solicitors to understand what can be done with the property. The managing clerk of the company attended her and advised her to sell the 2 cottages and invest the money in a better way. So she might be getting some rental income or otherwise from those cottages, but she was not satisfied. So the agent here, the managing clerk, said, you do one thing, you sell off these cottages and you invest the money somewhere and you will get better returns out of it. Now, so for the performance of this, she was asked to sign 2 documents, which was supposed to be sale deeds. Now, if I go to a solicitor and the managing clerk says, we are selling this and you sign it here, she signed it. And the documents were in fact gift deeds in the name of the managing clerk himself. So the managing clerk did a fraud and got gift deeds signed for those cottages. He then disposed the property and misappropriated the proceeds. He disposed of the property and he used the proceeds for himself. He acted solely for the personal benefit without the knowledge of his principal. It was held that since the agent was acting in the course of his apparent or ostensible authority, the principal was held liable for the fraud. See, he was doing it in the course of employment. Mrs. Lloyd did not meet the managing clerk outside the firm, the solicitor firm. She met inside the solicitor firm. She trusted the managing clerk because he was a part of the firm, and hence it was in the course of employment, and hence the principal was also held liable. Now, as contrast to this is another case where the person was not held liable. This is State Bank of India versus Shyama Devi. Now here, the plaintiff's husband gave some amount and check to his friend who was an employee in the bank for being deposited in the plaintiff's account, right? So the plaintiff's husband, Shyama Devi's husband, gave some money and which had to be deposited in her account. He gave it to a friend who was also an employee of the bank. Now, he gave it in the capacity of a friend. No proper receipt was obtained. You did not take a receipt when you gave the money. And the bank employee misappropriated the money. It was held by the Supreme Court that the employee, when he committed the fraud, was not acting in the scope of bank's employment, but in his private capacity as the depositor's friend. And therefore, the defendant bank could not be made liable for the same. Understand the difference between the two. In the first case, Mrs. Lloyd, when she gave the property papers and when she signed the property papers, she assumed and she had the reasonable reasons to presume that this was as per the firm's policy and the firm must have taken care of what the papers are. Here, when the person was giving money to his friend who was also a bank employee, he did not presume, he gave it as a friend who was also a bank employee. And he did not take the reasonable precautions to take receipts or to discuss about the same. So when the person was acting here as a bank employee, he was acting more in the capacity of a friend and not in the capacity of a employee. Had this been done inside the bank and giving it inside the bank, that would have been a different scenario. Now, the next category of persons are partners. Now, what partners? Partners in a partnership firm. Now, partners' relationship is also that of principal and agent. So, you are also liable like principal and agent. The rules of the law of agency apply in the case of their liability also. This means that partners are also jointly and severally liable for the acts done in the course of employment by each other. For the tort committed by any partner in the ordinary course of business of the firm, all other partners are liable. Therefore, to the same extent as the guilty partner. So, the tort committed by one, all other partners will be liable to the same extent. Hamlin versus Houston is a case. Now, one of the two partners of the defendant firm, acting within the general scope of his authority as a partner, bribed the plaintiff's clerk and induced him to make a breach of contract with his employer by divulging the secrets relating to the business. Now, there were two partners. One of the partner bribed somebody to get some business secrets out. It was held that both the partners of the firm were liable for this wrongful act committed by only one of them. Why? Because they also become joint tortfeasors. Partners are agents for each other. They become agents for each other. So when they become agents for each other, they are liable. Okay. The next category is master and servant. Now it says, if a servant does a wrongful act in the course of his employment, the master is liable. The servant, of course, is also liable. Like in the previous two cases where the principal and agent both are liable, and all the partners themselves are also liable and each other are also liable. Here also the master is also liable and the servant is also liable. The wrongful act of the servant are deemed to be acts of the master as well. The doctrine of liability of the master for the acts of his servant is based on the maxim respondent superior, which means let the principal be liable, and it puts the master in the same position as if the act has been done, as if he has himself done the act. So as if the act is done by himself. Okay. So here, master is liable for the acts of the servant. Of course, here also in the course of employment. In all categories of vicarious liability, understand the basic principle that the master servants are liable in the course of employment, partners are liable in the course of employment, principal agents are liable in the course of employment. It also derives validity from the maxim qui facet alum facet per se, which means he who does an act through another is deemed to do it himself. So one who does an act through another is deemed to do it in law to himself. Now, since for the wrong done by the servant, the master can be made liable vicariously, the plaintiff has a choice to bring an action against either or both of them. They are jointly and severally liable and considered to be joint tortfeasors. So, joint liability, joint tortfeasors, they can be jointly liable. Okay. The reason for the maxim respondent superior, that is, let the principal be liable, seems to be the better position of the master to meet the claims because of his larger pocket and also the ability to pass on the burden through insurances. So obviously the master is in a better position to pay back as against the servant, and hence you are holding him liable. He may also take insurances for the wrongs done and may be able to reduce his burden, and therefore the master is held liable. Liability arises even when the servant acted against the express instructions and for no benefit of his master. So in master servant, the liability is a little stricter. The liability of the master to arise, there have to be two essentials which are to be present. First, obviously, that the person who commits the tort must be a servant, and second, that the servant should do it in the course of his employment. Anything outside the course of employment, nobody is held liable. Okay? Who is a servant becomes a very important question, because principal agent, we understand there is contract law which we have read, and we will understand what is principal agent. Partners, it's clear in a firm, they are partnership firms, 50-50, whatever ratio, 30-40, whatever, but partners. Servant is a little tricky because there can be independent contractors also, and there can be servants also. A servant is a person employed by another to do work under the directions and control of his master. So under the directions and control of his master. So there are clear directions and control. In agent, there are not such clear control. Okay, as a general rule, the master is liable for the tort of his servant, but he is not liable for the tort of an independent contractor. So you are liable for the torts of the servant because you have you give directions and you control. A servant is an agent who is subject to the control and supervision of his employer regarding the manner in which the work is to be done. An independent contractor has no such control. So for the servant, you can clearly say that this is control, this is how you have to do, and you will supervise him. For an independent contractor, you just tell him what work has to be done, the manner of doing work, how he does. It's the own discretion of the independent contractor. The independent contractor undertakes to do certain work, and regarding the manner in which the work is to be done, he is his own master and exercises his own discretion. An independent contractor is one who undertakes to produce a given result, but so that is in the actual execution of the work, he's not under the order or control of the person for whom he does it, and he may use his discretion in things not specified beforehand. So a master and servant relationship, there is complete control. The master will tell what to do, how to do, when to do, and supervise. In independent contractor relationship, you will only be told that this and this work has to be done. How it is to be done, what is to be done, when, that all you will not be told. Okay? This is how a master-servant relationship is different from an independent contractor. We have to understand the liability of the employer for the acts of an independent contractor. First, let's understand that it's clear that master is liable for the torts committed by his servant. But an independent contractor, what happens? But an independent contractor is not liable for the torts, an employer is not liable for the torts committed by the independent contractor employed by him. The simple reason being that in the case of a servant, you are holding him liable because you are under direct control and supervision. You have complete control and supervision. But in case of an independent contractor, you do not have complete control and supervision. You only tell them about what work has to be done, how it is to be done, what manner it is to be done is their discretion. In Morgan versus Incorporated Central Council, the plaintiff, while he was on a lawful visit to the defendant's premise, fell down from an open lift shaft and got injured. The defendant had entrusted the job of keeping the lift safe and proper to certain contractors. It was held that for this act of negligence on the part of independent contractors, it is in not keeping the lift in a safe condition, the defendants could not be made liable. Why? Because you had already given that job to somebody else. You had given the job of entrusting or working on the lift or on the upkeep of the lift to somebody else, an independent contractor. Now you are not liable to keep going and checking what work you've delegated, right? If you would have given it only to your servant, you would have supervised it. You've given it to an independent contractor. That independent contractor is responsible to maintain that work. So it is that person's liability. Now, exceptions to the rule in case of liability of independent contractors. Now, what are the exceptions? There are many cases of accidents caused by mechanics, repairers, or owners of workshop during test drive of vehicle entrusted to them by the owners of vehicles for repairs. In the following exceptional cases, an employer can be made liable for the wrongs of the independent contractor. If the employer authorizes the doing of illegal act and subsequently ratifies the same, he can be held liable for such act. Now, in case of doing any work, there can be a legal method of doing it and illegal method of doing it. If you tell your independent contractor, no, you do it, no problem at all, this illegal method also, I am okay with it if the work is done. And then you ratify it also. Ratify it. See, approval is done before the doing of an act, and ratification is approving it after the work is done. That signifies ratification. So I take an approval before doing an act, it is approval. If I do an act and I tell you I've done this, is it okay? And you say, okay, it's okay. Then it is ratification. Now, an employer is liable for the act of the independent contractor in case of strict liability. The strict contract liability, also called no fault liability, also is a case where you need not show any fault. If such and such acts have happened, you are liable. And the liability of employer also arises for the dangers caused on or near the highway. So if some wrong is done near the highway, it is an exception that the employer will be exonerated of the independent contractor's liability. Then the employer will also be liable for the vicariously liable for the wrongs of the independent contractor. Now, fourth is, if the wrong caused to the plaintiff is nuisance in the form of withdrawal of support from the neighborhood land, the defendant would be liable irrespective of the fact that the act causing the said damage was done by the independent contractor. Now, there are certain relations which require continuous harmony and support. So if, for example, you had some wall which was giving some support to the neighborhood land and you remove it and cause nuisance, irrespective of the fact that the independent contractor has done it, you will also be liable. When the tort results in the breach of master's common law duty to his servant, he would be liable for the same. It is no defense to say that the master was acting through an independent director. So every master has some liability towards the servants to keep them safe, to keep them in a safe condition, to take care of them. If you breach those common law duties, you cannot take recourse of the independent contractor. Now, servants not under the control of master. We've understood one, that the servant has to be in control of the master. That is the control test. If it's not in the control of the master, you become independent contractor generally, and then your liability is not as stringent. Now, a servant is generally under the control of his master regarding the manner of his work, and there are various cases in which the master does not control or cannot control the work which can be done. So generally a master controls whatever work the servant does, but there are certain cases in which you cannot. So now what happens in these cases? The modern trend of authorities is to apply the hire and fire test. That is, a person who employs another person and is his paymaster and has the power to fire him or discharge him is the master for purposes of vicarious liability. Whoever hires, whoever pays, and whoever has the right to fire is the person who will be vicariously liable. If it is only the control test which is to be applied in every case, then the house surgeons and medical assistants of the state hospitals cannot be regarded as servants of the state. Why? Because you do not have control on how a doctor operates or how he will function. So hire and fire test is some new test to understand control. Okay. Now, this case of Rajasthan State Road Transport Corporation versus K.N. Kothari. In this case, the RSRTC hired a bus and a driver for running a bus on a specific route. So the State Transport Corporation, they hired certain buses to run on a specific route and the bus along with the driver. Now the corporation engaged a conductor who managed the bus, collect the fare, and also exercise control over the driver. The driver and bus were hired, and the manager, the conductor, you employed. It was held that for the accident caused by the driver, the hirer was vicariously liable, notwithstanding the fact that the driver continued to be on the payroll of the original driver. The Supreme Court stated that the transfer of effective control over a servant would make the transferee of the vehicle liable for vicarious liability. See, here you hired a bus, you hired a driver for a specific route, you also engaged a conductor to control the driver, and you had the right to hire or fire for that specific purpose. So even if the liability of, or for example, the ownership of payment did not transfer to you, but you had all other rights. So you were exercising effective control. Effective control was not on the person who gave you the employee. Okay? Now, what happens in cases of hospitals? Hospitals become tricky cases. Why do hospitals become tricky cases? Hospitals become tricky cases because in case of hospitals, doctors have a lot more discretion. So Cassidy versus Ministry of Health is one case. The hospital authorities were held liable when, due to negligence of the house surgeon and other staff during post-operation treatment, the plaintiff's hand was rendered useless. Here, the hire and fire test will apply. See how. Referring to the liability of the hospital authorities, Lord Justice Denning observed, it is no answers for the hospital authorities to say that the staffs are professional men and women and do not tolerate any interference by their lay masters in the work that they do. The hospital who treats a patient in doctor who treats the patient in a Walton hospital can say equally that the ship's captain who sails his ship from Liverpool. And in the case of crane drivers who works in the crane docks, I take no orders from anybody. By this he means that anybody who is treating anybody else or who's working on specialized mechanisms can say, I take no orders. But you will still be liable. Merely the fact that you employ professional men and women does not absolve you or exonerate you from any liability. That sturdy answers, as Lord Simon describes it, only means in each case that he is a skilled man who knows his work and will carry it out in his own. But it does not mean that the authority who employs him are not liable for his negligence. So even if a doctor is a skilled professional person who knows what has to be done, who is responsible to take quick decisions, who is responsible to take instant decisions, is an independent person, but does not mean that you will not be liable for the negligence. Now, what happens when you lend a servant to another? Here also the kind of authority you have given will be in question. When A lends his servant to X, servant X to B. Now you lend your servant to B, X commits a tort against C, some third person. The question is, who is to be considered the master, A or B, and whom can C sue for the tort committed? The answer to this depends on various considerations. The main consideration being as to who of the two servants has the authority to tell the servant not only what is to be done by him, but the way in which he has to work. So direction and control both have to be seen. Whoever has control and direction power will be liable. Mercy Docks and Harbour Board versus Cogents. Now this is another important case. A harbour board owned a number of mobile cranes and had employed skilled workmen as drivers of the crane. You had mobile cranes and you had employed very skilled people as workmen to drive those cranes. It was usual for the board to let out the cranes, each being driven by the skilled driver employed by them. You always lend out things. Certain stevedores hired a crane together with the driver for loading a ship. And due to the negligence of the driver, X was injured. The House of Lords held that the Harbour Board, who was the general and permanent employer, was liable. Why? Because in this case, there was no control and direction by the persons who hired. Stevedores who hired had no control and direction. They only hired to pick up and load. So in this case, the effective control and direction was in the case of the main employer, and hence they were also held vicariously liable. The stevedores were not liable, even though at the time of negligence, the drivers were loading the cargoes of the stevedores. The reason for the decision was that although at the time of accident, the stevedores had immediate control over the crane driver insofar as they could direct him to pick and move certain cargo. But that alone could not make them liable. I tell them to pick it from here and put it here. This is the only effective control I have. Other than that, I don't have any control. They had no power to direct as to how to operate the crane. The question of liability depends on many factors and the important considerations. Who has the power to direct as to how the work is to be done? How? Effective control and direction. This is important in case of vicarious liability. In the words of Lord Potter, many factors have bearing on the result. Who is the paymaster? Who can dismiss? How long the alternate services last? What machinery is employed? Will all have to be kept in mind. But the ultimate question is not what specific orders or whether any specific orders were given, but who is entitled to give the orders as to how the work should be done. So what is not important? Who is important? Who gives those orders? It was also observed that in the Mercy Dock case, the power of control is presumed to be in the general employer, and the burden of proving the existence of power of control in the hirer rests in the general employer. So you are presumed, whoever hires you is presumed to be in general power. The transfer of power is for the general employer to prove that you have either transferred or not transferred. Now, hiring. What happens in hiring? In the case of hiring, a presumption has been generally raised that there is only transfer of service and not of servant. If I hire a bus and driver, I am only taking their services. I am not taking their servant. The general employer is free to rebut the presumption and prove that when the servant was lent, effective control over him was also transferred, and thereby he can avoid liability. So the general presumption is that there was a transfer of service only, but the general employer can prove it otherwise. Now, what happens in a casual delegation of authority? Generally, I delegate, you see what has to be done. Generally, for casually. For the purpose of vicarious liability, it is not necessary that there must be long-term servant-master relationship. Even when a person for a single transaction authorizes another to do something for him and the latter does it negligently, the former can be made liable for the same. Even if one thing you are the person who is controlling and authorizing, for that one action also you can be held vicariously liable. Now, let's understand what is course of employment. Course of employment means in the period of employment, during of employment. A master, like a principal, is liable for every act which he actually authorizes. There has to be actual authorization. The liability of a master is not limited only to the acts which he expressly authorizes, but also he is also liable for such tort which are committed by his servant in the course of employment. So I actually authorize doing something, and in the course of employment, whatever happens. An act is deemed to be done in the course of employment if it is either a wrongful act authorized by the master or a wrongful and unauthorized mode of doing an act authorized by the master. So either you do a wrongful act or you do a wrongful and unauthorized method of doing a right act. Okay, so in both these cases you are liable. Now, a master can be made liable for such unauthorized acts as for the acts he has authorized. Okay, so such authorized acts as per the acts he is authorized, that means that unauthorized methods of doing authorized act. However, for an unauthorized act, the liability arises that if that is within the course of employment, that is, it is a wrongful mode of doing what has been authorized. Thus, if I authorize a servant to drive and he drives negligently, or I authorize a servant to deal with clients and he deals with them fraudulently, or if I authorize a servant to help the railway passengers, but he mistakenly causes harm to them, in each the servant is doing the act which he's been authorized to do, but his method may be wrongful. So anything which I authorize and the method becomes wrongful, in that case there is liability. Each one of these acts is therefore within the course of employment and the master can be made liable for the same. Unauthorized methods of doing authorized acts is what will cause vicarious liability. There is, however, no liability for the act which is neither authorized nor a wrongful method of doing what has been authorized, because the same is not considered to be within the course of employment. So if it is not within the authorization capacity, not in the course of employment. Thus, if I send my servant to make some purchases for me from the market and he utters some defamatory words there, the defamation by the servant is out of the course of employment and I cannot be made liable for the same. Defamation is not a part of purchasing something, so it is out of the course of employment. What happens if a servant steals something, causes theft? Now, Morris versus C.W. Martin and Sons. In this case, the defendants were bailies of a fur coat given to them for cleaning. They might be some dry cleaners or something, and a coat was given to them for cleaning. They gave this coat to their servant Morrissey for cleaning, and he stole the coat instead of cleaning the same. It was held that the act of the servant in stealing the coat, to whom the same had been entrusted was cleaning, was a wrongful act done in the course of employment, and the master is liable for the same. Justice Diplock, what did he say? The defendants cannot, in my view, escape liability for the conversion of the plaintiff's fur coat by their servant. Here they were bailies and somebody used it, stole it, so it becomes conversion. They accepted the fur as the bailies for the reward in order to clean it. They put the servant as their agent in their place to clean the fur and to take charge of it while doing so. The manner in which he conducted himself in doing that work was to convert it. What he was doing, albeit dishonestly, he was doing in the scope of his employment in such technical sense of the same thing. The defendant as his master are responsible for his tortious acts. The position becomes a little different, and it says the position would be different if the goods in possession of the master by way of bailment are stolen by the servant to whom the goods are not entrusted. Now here the good was given to that servant to clean and then he stole it. If it is not given to any servant, then you are not in the course of employment. In such a case, the theft by the servant would be an act outside the course of his employment, and the master cannot be made liable for the same. Justice Allen says, a bailey for reward is not answerable for theft by any of his servant, but only for such a theft as by such of them as are deputed to him by discharge of some part of his duty of taking reasonable care. A theft by a servant who is not employed to do anything in relation to the goods bailed is entirely outside the scope of his employment and cannot make the master liable. If there are 10 servants and I do not give that thing to 10, I give it only to 1 and the 9 are not responsible for it, then for the theft caused by any one of those 9, the master will not be liable. Now, what happens if there is a mistake? Where the servant having lawful authority to do some act on behalf of his master makes erroneous or excessive use of authority, causing loss to the plaintiff, the master will be liable for the same. A servant has implied authority to protect the property of his master. If the servant in an attempt to perform such duty uses excessive force, the act will fall in the course of employment. What happens in negligence? Again, if it is within the scope of authority, master liable. If it is not, then not. If a servant is not careful in the performance of his duty and his conduct causes any loss to a third party, the master will be liable for the same. Sometimes a servant may do an act while performing the duty assigned to him by the master for his own convenience of comfort. The question which in such cases arises is how far the act is to be considered to be within the course of employment. Now, you will have to understand we've understood within the course of employment. Now, what happens in acts outside the course of employment? When a servant does any act which is not in the course of the master's business, the same is deemed to be outside the course of employment. An act may be done in the course of employment even though it is not strictly in the performance of the duties of the workman. For example, a workman driving a little away from the place of his work for his midday meal. But if certain workmen who are permitted to use their master's vehicle for having refreshment decide to go for a tea or to a cafe to a distance of 7 miles, and on their way, due to negligence of one of them, another workman is killed, the negligent act cannot be considered to be within the course of employment and the master cannot be held liable. If it is a little deviation, you have to see how much is it. It's all based on the facts of the case. Now, Tory versus Ashton. In this case, a carman, while on his way back to his employer's office, was induced by another employee to turn off in another direction for picking up something for the employee. The carman was going in this new direction and an accident was caused. The master was not held liable because if the carman had been merely going on the roundabout way home, the master would have been liable. But he started on an entirely new journey on his own or his fellow servant's account and cannot in any way be said to be carrying out the master's employment. While you are doing the work of the master, if you do something, you are liable. But if you take a new turn and you do something, the master is not liable. Negligent delegation of authority. Now, what happens if the servant only delegates the authority? What happens in that case? If a servant negligently delegates his authority instead of himself carefully performing a duty, allows it to be negligently performed by other, the master will be liable for such negligence. Now, what happens? India Insurance Company versus Radhabhai. The driver of a motor vehicle belonging to the state government who asked to bring ailing children to the primary healthcare center gave control of the steering wheel to an unauthorized person and the accident was caused. Here, the master was held liable for the unauthorized mode of doing a authorized act. Remember, unauthorized method of doing an authorized act? In the course of employment, liability arises. When the act of the servant falls within the course of employment of his master, the master is liable. It is no defense to say that the master had taken due care in selecting a competent servant or the circumstances were such that the servant himself would not be made liable to injured party. That is, he was the husband of the injured party. So you cannot say that we have some relation or you are liable. You are, if a wrongful act is done within the course of employment, even if it is the unauthorized method of doing that, you are held liable. Now, what happens if there is express prohibition to do something? Sometimes the employer forbids his servant from doing certain acts. It does not necessarily follow that an act done in defiance of prohibition is outside the course of employment. If prohibition were to be defiance, every employer would escape liability by issuing orders to forbid his servant from committing any tort. There would be express order, do not commit any tort. So express prohibition does not absolve liability. Twinney versus Beans. Here in this case, the defendant provided a commercial van and a driver for the use of the bank. And the driver remaining the servants of the defendant. Okay, so you give your driver and your van to the bank, and the driver was the servant of the defendants only. Defendant had put up two notices on the van. One notice indicating that no unauthorized person was allowed to take lift in the vehicle, and second mentioning that the driver had been instructed not to allow unauthorized persons in the van, and that in no case will the defendant be liable for damage to such unauthorized persons. The driver nevertheless gave lift to an unauthorized person who was killed owing to the driver's negligence. In this case, the act was held to be outside the course of employment, for which the liability of the defendant did not arise. Why? Because you were expressly written, express order. Driving a van and giving a lift are two different things. So you are not liable. This is what is the end of vicarious liability.